Hello and welcome to a very special edition of the Privacy Corner, where I'm joined by a very special guest to discuss a very special law, Washington's My Health, My Data Act, which will start to take effect on the 31st of March. Now, of all the privacy laws passed across the United States last year, the My Health, My Data Act is possibly the broadest and most significant, despite its supposed focus on consumer health data. So with me here today is Keir Lamont, who is director of the Future of Privacy Forum's US legislation team, and in my opinion, one of the world's foremost experts on the tsunami of new privacy laws emerging across the states. Keir, thank you so much for joining me. So tell me a bit about how you came to be so well-versed in these US state privacy laws and what you do at the Future of Privacy Forum.
Well, thank you so much for having me. It's really a delight to appear and speak with you, Robert. You mentioned I spend a lot of time tracking and following the states, particularly posting on LinkedIn. And I feel like you do what I try to do, but for the entire world. I think the whole privacy community really benefits from what you bring, the resources you put out, and especially the Privacy Corner newsletter.
Oh, you're very kind.
So, appreciate it. So at the Future Privacy Forum, I'm on the US legislation team. FPF is a think tank, and we spend a lot of time looking at the privacy laws and kind of comparing them to what has been done in other jurisdictions. So a lot of really comparative analysis trying to track emerging trends in what these laws try to do and how they are enforced. The reason I spend a lot of time focusing on the states is that for the most part, Congress has not had its act together for the past 20 years or so here. My understanding is the United States is currently the only G20 nation now that lacks a comprehensive overarching framework to govern the collection, use, and sharing of personal data. And into that vacuum, states have been increasingly stepping up to protect their citizens. You and I talk a lot about some of these, what we call comprehensive state consumer privacy laws, but we also see some sectoral consumer privacy laws that can also be extremely impactful. And in my view, the Washington State My Health, My Data Act that we're about to turn to in just a moment here is definitely one such law.
Yes, indeed. Well, so first things first, Keir, I wanted to ask you a bit about the application of the My Health, My Data Act. And maybe you could talk a bit about the kind of framing and intent of the legislature. Now, while it only applies to companies processing consumer health data, I think it could hit a lot of businesses not covered by other states' privacy laws. What do you think?
I think that's absolutely true. The My Health, My Data Act is it's a very complex bill. It has some very interesting drafting choices. But I do want to state up front, and you did allude to this, the My Health, My Data Act was very explicitly framed as a reaction to the US Supreme Court's decision in Dobbs v. Jackson Women's Health, which struck down a long-standing established precedent for certain reproductive care in the United States, specifically the right to obtain an abortion. We also have a very recent line of enforcement actions from the US Federal Trade Commission, which I know you've also been tracking, cases like BetterHelp, GoodRx, Premom, and Flow, that demonstrate that certain market participants have been playing very fast and loose with selling and sharing sensitive consumer health data without necessarily obtaining informed consent. So I do think it is important to keep in mind that the My Health, My Data Act seeks to address very real issues that can have genuine risk and pose genuine harm to individuals. Now, you mentioned the My Health, My Data Act has a very broad application. That's absolutely true. And when we talk about these US state privacy laws, I think there are two different elements that can indicate breadth. First, who is covered? And second, what is covered? So the My Health, My Data Act applies to organizations doing business in Washington state or that provide products or services targeted to Washington state consumers that process consumer health data. Typically, many of the state privacy laws that we follow carve out small businesses and often also carve out nonprofits. They also often carve out businesses that are already regulated by existing federal privacy laws. The My Health, My Data Act takes a different, broader approach. There is no small business exception under the My Health, My Data Act. However, there is a 3-month delay in the effective date for those small businesses. The My Health, My Data Act does have some exceptions. It has exceptions for data that is subject to enumerated federal privacy laws, notably HIPAA, GLBA, FCRA, and FERPA. However, not businesses in their entirety subject to those laws. So that's a distinction from most of the state privacy laws that we talk about. My Health, My Data does carve out employee and business-to-business data. That's information that is exempt in most states except for California. There are also exclusions for de-identified as well as publicly available information, although there's a question about how they drafted that definition of publicly available information. And also then finally, government entities, tribal nations, and processors that process on behalf of the government agencies are also carved out. So that's who is covered, and that's quite broad on its face. And then we turn to what is covered. The Act applies to consumer health data, which I think unfortunately has led to a lot of folks in industry tuning out when this law comes up. They'll say, look, I'm not in the consumer health data space. This isn't something I need to worry about. However, even if you're not in the health space, you may process consumer health data as it is defined under the Act. Consumer health data is defined extremely broadly. It includes personal information that is linked or reasonably linkable to a consumer and that identifies that consumer's past, present, or future physical or mental health status. The definition also offers a non-exclusive list of things that constitute consumer health data, some of which appear very open-ended and likely to pull in data sets that are not typically thought of as health information. For example, this includes data that reveals social interventions, relates to bodily functions. It includes biometric and genetic data, defined much more broadly than biometric data is typically defined under other state privacy laws. It includes precise location information that could reasonably indicate a consumer's attempt to receive healthcare services or supplies. And it also includes data that identifies that a consumer is seeking healthcare services. And that one could pull in a lot of web activity and traffic and online searches and things of that nature.
Yeah.
And so I think just to conclude here, it is worth actually contrasting that definition with protections for health data that we typically see under other state privacy laws. Robert, I know you've written about New Jersey, which recently passed S332, which defines and protects health information as personal data revealing mental or physical health condition, treatment, or diagnosis. There's also a bill, Nevada SB 370, that was enacted actually a few months after the Washington State My Health, My Data Act. It's of a similar scale. It takes effect on the same day, but we're probably not talking about that law because it doesn't include a private right of action. But that law defines covered health information as information that a regulated entity actually uses to identify that past, present, or future health status. Mm-hmm. And that's different than just data that on its own identifies health status. And it also excludes data used to provide or enable access to video gameplay, explicitly excludes certain information about shopping habits or the interests of a consumer. So where does that leave us with the My Health, My Data Act? I think businesses, even if they're not traditionally in the health privacy space, are going to want to take a very close look at the data sets that they collect and share and ask themselves whether or not that information could be considered consumer health data under this law.
Yeah, you raised so many important points there. And I did want to go back to the first thing you said, which grounds this conversation in the seriousness of, what's at stake. I had actually, when I saw these consumer health privacy laws emerging and the FTC's attitude towards health apps, resurrecting the health breach notification rule. And I knew that was flowing from the Dodds decision, but that had actually passed from my mind and I'd forgotten about that very important context. So while we are, I have some issues with the drafting in some sections of this bill, but we do have to remember how important health privacy is, especially in that context. And so you mentioned Nevada's attempts to pass a similar law here. Well, success in passing a similar law, but that is more narrowly focused, as you mentioned. It's about the intent, I suppose. Whereas the Washington My Health, My Data Act might catch a lot of companies out without them realizing that what they're doing is collecting or processing consumer health data. Another thing I think we're talking about the breadth of this law. So I wanted to talk a bit about the drafting. So we'll probably talk later. You need consent under this law beyond the purposes for which you are using data, as requested by the consumer. You need consent before collecting or sharing it, with some very limited exceptions. I'd just like to read you the definition of collect, because I find this very interesting, and I want you to help me understand. So collect means to buy, rent, access, retain, receive, acquire, infer, derive, or otherwise process consumer health data in any manner. Now, do you think they drafted it so broadly on purpose? We have process in any manner at the end here. From my European standpoint, processing means doing anything. We had processing defined as speaking by the CJEU in some contexts the other day. So does collecting consumer health data include deleting it? For example, what are the implications here with this broad definition?
I think you raise a really important question about the My Health, My Data Act, and something that regulated entities and regulators probably will be struggling with and thinking about as this law takes effect and as it goes into enforcement. I think you raise a very good point in both to just regular people as well as in most global privacy or data protection law. Collecting personal information typically means to acquire it or to receive it from the consumer or from some third party. However, as you mentioned, under the My Health, My Data Act, collecting includes any processing, and processing data is defined under the Act. So if collecting includes any processing, why is there a separate definition for that term? It's a great question. And this is a really significant point because the Act establishes protections for people whose consumer health data is collected in Washington state. And so that implies that even if the data is collected, originally obtained in some other jurisdiction, this Act may have an extraterritorial effect if that data is ever processed in Washington state, for example, passes through cloud computing infrastructure or a technology to that effect. And Washington state sure does have a lot of data processing centers and cloud computing infrastructure. You also mentioned, I think, a really interesting point here. Processing does include the deletion of data. So since in many cases, consent is required to collect data, are businesses actually required to hold on to data forever unless they obtain opt-in consent to delete it? I would certainly hope not, but that's one of these kind of thorny practical implementation questions here that regulated businesses and lawmakers will have to think through.
Just to come in on that point, I don't want to invoke Schrödinger, but of course, storing consumer health data would also be processing it. So you don't, there's no way out there. You're storing it, you process it. If you delete it, you're processing it. So it always puts you in a catch-22 there. I think that, we could see just some common sense interpretation of this by regulator, by the Attorney General in some context. But here, of course, we have a private right of action. And if I know US litigation culture, I'm pretty sure there will be some law firms I don't want to say taking advantage, but using this very broad definition to launch lawsuits. What do you think about that idea? Is that a possibility?
I think it is definitely kind of a concern. And you asked me again, kind of at the front here, why this broad definition of collect. Honestly, I do not know. Some interesting background here that a lot of people may not know about the My Health, My Data Act is that it was actually modeled on a federal bill called the My Body, My Data Act, which was introduced back in June of 2022. It never ultimately went anywhere, Congress being what it was and is. But in preparation for this call, I actually went back and looked at the text of that proposal, thinking that, Washington State probably copied in that same definition of collect. But actually, no. The My Body, My Data Act, the federal bill, did define collect as to obtain data in any manner, so somewhat narrower. So this definition of collect is something that Washington State put in. I do not have information or knowledge of why this broad definition.
So that's it. I'm glad you agree that it is very broad. I suppose let's not get distracted by that. Let's talk a bit about what this law requires. So you've recommended, well, you suggested that businesses might want to look at the data they process and consider whether it could be consumer health data. What happens if they find out that it is? What are the requirements under this law? Can we talk about sharing? And also, could you talk a bit about selling consumer health data and the very high bar that the law sets for doing that?
Absolutely. So in terms of overall substance of the act, there are some requirements, consumer rights that will look pretty familiar to most businesses. There's kind of the access deletion type consumer data subject rights, although framed somewhat differently and somewhat different exceptions and details than we see in other states. There's also a requirement that businesses post a consumer health data privacy policy. It's not necessarily clear to me whether or not that privacy policy can be part of the existing privacy notice, or if it has to be a standalone document. But then the main thing that this law does in an attempt to protect this consumer health data is establish very strict and stringent requirements for consent. And it actually establishes two separate tiers, distinct tiers of consent, which is something pretty novel, and I don't think I've seen in many contexts before. I will say that consent is actually a very common element in many US privacy laws, and especially in the States. That standard for consent is often copied verbatim from the European General Data Protection Regulation. I'm sure you know what that is. I'm sure everyone can say it with me. Consent must be freely given, specific, informed, and unambiguous.
Yeah.
The My Health, My Data Act has those elements, but does add in two more.
Yeah,
That must also be
extra adjectives in there. Adverbs.
Yes, also be opt-in and voluntary.
Mm-hmm.
Will those additions change anything in practice? I would guess probably not. But typically, consent is required under US state privacy laws in order to process sensitive data. The My Health, My Data Act takes a somewhat different approach in framing. Consent is required for the collection or sharing of consumer health data unless necessary to provide a requested product or service. And there is also some additional substance and details around that. With consent, it must be disclosed the categories of health data that will be collected or shared, the purposes of collecting or sharing, the categories of entities who will be shared with, and how consent may be withdrawn. So this adds up to a fairly strict and prescriptive kind of notice and choice regime, but nothing that is probably insurmountable for most regulated businesses. However, that is just the lower tier of consent. My Health, My Data Act creates a second higher tier of consent, and that is in order to sell consumer health data, a business must obtain what is called valid authorization from the consumer. And note that sale and selling consumer data under this bill is defined very broadly. It includes exchanges of personal data for money, but also for other valuable consideration. Now, that is a standard that does exist under other US state privacy laws, your Californias, your Connecticut's, for example. And it has been interpreted somewhat broadly to encompass many of the types of data transfers that underpin online advertising. I think online advertising is squarely in the target of this bill. So I mentioned valid authorization. Valid authorization under the My Health, My Data Act requires completing a document that includes things like information about the specific health data that a business intends to sell, contact information for the business selling the data and the business receiving the data, a detailed description of the purpose of this sale. This authorization has to expire after 1 year. A signature and date from the consumer must be obtained, and the seller and receiver of the consumer health data must retain a copy of this valid authorization document for at least on a 6-year retention schedule. So look, I am not in compliance. I'm not in Washington State, but I have not seen anyone at this point attempt to draft one of these valid authorization documents. It seems very, very difficult in many cases. And if there's anyone out there who has one of these valid authorization documents, if you've seen one of them in the wild, I would be very interested to take a look at how organizations are attempting to meet all of these requirements.
So the sale definition, as you say, is very broad, and it has been interpreted, but we haven't had a lot of enforcement under these state privacy laws yet. But we know how the wind is blowing. We've seen it in California. This can include a lot of stuff. It came up in the DoorDash case recently in California. Different jurisdiction, of course, but there we had non-monetary, the consideration for an exchange of personal data. And that was deemed to be a sale. We all knew, of course, anyone paying attention knew that that is encompassed by this definition. I wonder even if they were making a point by choosing a case wherein there was no money exchanging hands. It was a kind of mutually beneficial cooperative. So the breadth of all these different provisions taken together, the strictness of this law, and of course, the very important context in which it has been passed, do you think we will see a lot of enforcement? Well, tell us a bit about how enforcement works, because my understanding is it's just a private right of action. I could be wrong about that, so do correct me if I am. And how do you see this playing out? Is it another BIPA, in Illinois? Are we going to see a lot of cases under this law, do you think?
Sure. So it's a really great question. It is the case, like most US privacy laws, the My Health, My Data Act will provide for enforcement by the state attorney general's office. The Washington State AG has been somewhat active in the run up to the law taking effect. It has published and updated some frequently asked questions on its website that attempt to clarify some of the more confusing aspects of the act. However, unlike the vast majority of other US state privacy laws, the My Health, My Data Act does establish this private right of action, which again is why we're here today talking about the My Health, My Data Act, I think, and not the similar Nevada SB 370 or any one of these other state privacy laws that are going to be taking effect in the next couple months here.
Yeah.
And so, look, I gotta clarify, I'm not a litigator. I'm sure as heck not a Washington State litigator. I don't like making predictions, so everything I say here should be taken with a grain of salt. But it is very, I think, instructive and informative, and you alluded to this, that to date, really the only example that we have in the state privacy context of a law that has a broad private right of action, the ability for individuals to sue to enforce alleged violations of the statute, not just government regulators, is that Illinois Biometric Information Privacy Act, which actually dates back, I think, to 2000, before the advent of modern smartphones. And so it passed in 2008, but really it's only been over the past 4 to 5 years that Illinois law BIPA has emerged as a very popular tool for trial attorneys. And at this point, I think we have over 100 BIPA cases filed every year. And I think a reason for that is that if you show a violation of the act, you are entitled to recover statutory damages. You're entitled to money, and you don't necessarily have to show actual damages. Though, to be very fair, there's definitely a very reasonable argument to be made that if your face or your palm is scanned and turned into a template for recognition without your knowledge or consent, that in and of itself can constitute an harm. So that is how statutory damages and how private rights of action has operated under that Illinois statute, BIPA. And I will actually note that there was a bill that just got through the Illinois Senate Judiciary Committee this week that would seek to substantially revise the BIPA private right of action. But that's probably a conversation for another time. However, and this is important to emphasize, that Illinois approach is not the approach that the Washington My Health, My Data Act takes. The My Health, My Data Act links enforcement to Washington's underlying Consumer Protection Act, its provisions establishing procedures for filing and recovering in private rights of action. This is sometimes called a backdoor private right of action in US privacy discussions. And that Washington Consumer Protection Act requires that a plaintiff show an injury to their business or property in order to succeed in a lawsuit. It's not simply the case that showing a violation of a statute, not dotting an I or crossing a T on those consent authorizations, for example, entitles you inherently to monetary compensation. Instead, the Consumer Protection Act permits recovery of actual damages, the costs of the suit, reasonable attorney's fees, and sometimes in the court's discretion, the possibility of recovery of what they call treble damages, not to exceed $25,000 in particular cases. So we are not in a world where merely showing a procedural violation automatically gets the business on the hook for a big financial penalty. I will note that if you want to know more about the Washington State Consumer Protection Act's private right of action, the place to probably start is the Hangman Ridge versus Safeco case from 1986, which kind of laid out the current elements necessary to succeed on a private right of action claim. I am probably not the lawyer to talk to about that case, however.
Yeah, that is why I wanted you for this show, the deep cuts, the 1986 Washington State litigation. I love it. I did look into that consumer protection law, and I noticed this triple damages provision in some analysis of it. And I think you've identified the key difference there, though. Although many law firms will stretch, I think, this definition of harm as far as they can. We've seen under CCPA, for example, which has a very limited private right of action. I had a lot of cases coming through that, not to name any specific case, but a lot of them do not appear to meet that threshold. But will still be a lot of energy and time and possibly cost for businesses to defend against. But yes, you're right. So the key difference there is that with BIPA or BIPA, and the only one that says BIPA, I can't help myself. You only need to show a violation of the law per se. Whereas with the Washington My Health, My Data Act, you do need to show that you've been injured in some way to your business or property, you say. So that is a very important distinction. Nonetheless, we have a very broad law here, as we keep saying. We've got lots of different types of data encompassed under this consumer health data definition, including things like mobile IDs, geolocation, as long as they show something about a consumer's past, present, or future health condition, they are covered. And given the state of privacy in the US, I anticipate some pretty broad interpretations of these provisions, even though they are already broad on paper. So it's a very important law here, and it's passed for a very important reason, as you remind us at the beginning of our conversation. Thank you so much for coming here and talking to me about it. It's been an absolute pleasure to get to meet you as a longtime fan of your work. And thank you for explaining so eloquently the scope and the implications of this important law. So we have 31st of March for regulated entities. Small businesses get a short extension sometime in June, right? That it kicks in for them?
June 30th.
Okay. Well, that's a date to have marked in your diary, I think. If you have anything to do with Washington State, do have a look at what you're doing and whether you might be covered by this law. Keir, thank you so much for talking to me. It's been a pleasure to meet you.
It's been an absolute pleasure. Thank you for having me on.
And thank you, as always, of course, to Bravado AI for their support of the show. I've been Robert Bateman, and I'll see you soon.